Hey everyone, it is Rob Ryder. Sunday, October 2nd, 2016. Today we're going to spend some time talking about some people called the enrolled agent, who are your attorney before the IRS. And a couple of quotes worth mentioning are enrolled agents status is the highest credential the IRS awards. And Congress endowed enrolled agents with the power of advocacy to prepare claims against the government. And so we're going to study who these people are, and this fits in with the last few videos I did about we're trying to figure out how to take IRS documents that would have been created as part of a QSIP production. So it could be a court case, or it could be your mortgage-backed security, or whatever it is that created the QSIP. Apparently to do that, there's some IRS paperwork that has to be put in, like a 1099 OID and a 1099B. And apparently they also put in a 1099A, which means either acquisition or abandonment. And these documents, as I pointed out in my last videos, would show that you are the owner. Now, I haven't seen it myself. I'm saying what people have said and written before and wrote 50 attorney generals telling. I'm going to go with the fact that, that they're not lying. But I haven't seen it yet myself, and so it's how do you go see this stuff, and what's the proper way to do it? Instead of trying to do it all ourselves, let's go find an expert. Well, that's who the enrolled agents are. So let's see what they can do for us. As I said, this is Sunday, October 2nd, 2016. My email address is courtofrecord@aol.com, and my phone number 616-712-6179 if you really have to call me. And if you can, I would ask you to please donate. Always, if you can, please donate. I try to do this all the time, and to do this all the time, well, then somebody has to pay the few bills I have, and I try to live as cheap as I can, but, nothing's free. So my PayPal account is using my daughter's PayPal account, ashleyrytlewski@gmail.com, ASHLEYRYTLEWSKI@gmail.com. Credit card, well, robryder@aol.com. I opened a PayPal account. I haven't tried it yet, but I'm supposed to be able to use credit cards on it. You could use the mail to Robert Rytlewski at 10955 14 Mile Road, Northeast, Oakfield, Michigan, 49341. And to all those who have donated, thank you so very much. I mean, it's been the last minute, I don't know how many times, and it has come through, and praise Jesus, right? I'm a very, very humble and thankful man. Thank you so much. I'll try to get back. So let's do some stuff for the common good. First of all, if you were to go to, to Google and just put in enrolled agent, you would find hits like on the IRS website, enrolled agent information. What is an enrolled agent? That's on the National Association of Enrolled Agents website. More from the NAEA and Wikipedia. So a lot of what I'm going to read next is just what I have copied and pasted from there, because it's a little bit easier for me to keep track of. So what is an enrolled agent? An enrolled agent is a person who has earned the privilege of practicing, that is, representing taxpayers before any office of the Internal Revenue Service. An enrolled agent can negotiate with the IRS during examinations and appeals and act in place of a taxpayer, signing consents and executing agreements on their behalf. An enrolled agent is the only professional granted a right to practice directly from the U.S. government. I have to read that again. An enrolled agent is the only professional granted a right to practice directly from the U.S. government. Attorneys and certified public accountants, that would be your CPAs, have state licenses, which limits their practice only to the states where they are licensed. So let's think about this then. If you're in Michigan and you're doing your taxes and you have a CPA do it, and then you need to send it to Ogden, Utah, or wherever the hell it goes to, I believe it's probably Cincinnati, you just cross state lines. That attorney doesn't have, or CPA doesn't have any jurisdiction in Cincinnati. Right? So I don't know if that's what they're doing or not, but that is what is. So there's a reason to use an enrolled agent. Unlike a CPA or attorney, an enrolled agent holds a federal license, and has the right to represent any taxpayer in any state regarding federal tax matters. Now, it didn't just say income tax, and this is where they get us. There are many kinds of federal taxes. Income tax would only be one. And so excise taxes are federal taxes, and so is employment taxes. And it just seems like they're doing what they can to keep us from showing up in a certain jurisdiction and paying the tax, because then they would have to act like they'd have to acknowledge that we're here. Okay. An enrolled agent is, unlike a CPA, enrolled agent's federal license. An enrolled agent is considered a tax specialist, which sets them apart from attorneys or CPAs who do not always specialize in taxes. Who's the tax specialist? The enrolled agent. The practice of enrolled agents before the IRS is not limited, and they may represent taxpayers before the IRS, performing the same task as attorneys or CPAs. The capabilities of enrolled agents extend beyond just preparing returns to areas such as representing clients in cases involving audits, collections, and appeals. And, hey, we want to have an audit. I tried to get an audit from the IRS, and they wouldn't call me. And so I had complained to TIGTA, the Treasury Inspector General for Tax Administration, and he called me, or one of his agents did. And that's, 5 or 6 years ago now, one of the very first things I had done in this endeavor of trying to figure out what's going on in the world. And I had a really nice conversation for an hour and a half with a couple of Treasury agents, bought me 3 cups of coffee, and said that was the most intelligent explanation they'd ever heard for why a man believes what he believes. It was a good day. Okay, so these enrolled agents is a type of tax advisor who is federally authorized tax practitioner empowered by the U.S. Department of Treasury. By who? Well, by the U.S. Department of Treasury. Not just the IRS, by the U.S. Department of Treasury. Well, that would be the Secretary of Treasury has empowered them. Enrolled agents represent taxpayers before the Internal Revenue Service for tax issues, including audits, collections, and appeals. Well, that sounds like court. When somebody represents you before something, isn't that a court? I guess the IRS is a court. Well, it is. And they have an IRS court, or they have a tax court. And I believe that those are the court of exchequer, not a court of law, and that's why you don't need an attorney at law. You need somebody who can represent you in the court of exchequer. Because we're trying to get a remedy in equity, and this comes out of Lord Blackstone, Commentaries on the Laws of England and Wales, Book 3, Chapter 27 or 29, something like that, where it talks about the courts of equity, and that they each have their own jurisdiction. And in things to do with the king's revenue and duties of the king and returning property that the king may have that is yours, well, you need to go to the court of exchequer. So who collects the king's revenue? Well, that would be the IRS. So it's the court of exchequer here in America. All right? And so that possibly being a case, well, let's just go and say it is for a few days and see what we can make anything out of it. So enrolled agent status is the highest credential awarded by the IRS. I didn't say it, they did. The EA credential is recognized across all 50 states. Attorneys and certified accountants are licensed on a state-by-state basis and are also empowered by the Department of Treasury to represent taxpayers before the IRS, but only in their state. According to the National Association of Enrolled Agents, that's the NAEA, there are approximately 48,000 practicing enrolled agents in the United States. So just real quick, let's go to that site just so you can see. If you were to click on this, because I may forget to go back later, see where it says find a tax expert? Yeah, if you go in here, and you can put in your zip code, and it will find one for you. All right, so it's that simple. So the history. The position of enrolled agent was created as a reaction to fraudulent war loss claims in the wake of the American Civil War, with roots tracing back to the Enabling Act of 1884, or General Deficiency Appropriation Bill, H.R. 2735, also known as the Horse Act of 1884, which was signed into law by President Chester A. Arthur on July 7, 1884. After the Civil War, many citizens faced difficulties in settling claims with the government for property confiscated for use in a war effort. As a result, Congress endowed enrolled agents with the power of advocacy to prepare claims against the government. From 1884 through the early 20th century, this statute remained largely unchanged. And so these enrolled agents were created under an act of Congress. Why make them a federal agent? When the Revenue Act of 1913 was passed, signed into law by President Woodrow Wilson on October 3, 1913, the scope of the enrolled agent was expanded to include claims for monetary relief for citizens whose taxes had become inequitable. And this is what's happening to us, because on your tax form, the person whose taxes they are is somebody with a middle initial name. On mine, it would say Robert A. Ritlewski. Well, that isn't me. It's a legal fiction. It's a pseudonym. It's a nickname. It's an unregistered alias. But it's not me, and I'm not paying his taxes. Right? And so you've been paying the taxes of somebody other than yourself, a legal fiction, instead of paying your taxes. So, hey, we've been inequitably taxed. As income, estate, and gift and other sources of tax collections became more complex, the role of enrolled agents increased to include the preparation of many tax forms that were required. As a result of this complexity, audits became more prevalent, and the enrolled agent's role evolved into taxpayer representation. So I'm thinking I want them to do an audit in my account and represent me and fix the errors. Proclamated a series of statutes which were combined into a single Treasury Department circular. February 19, 1921, notice Circular 230, to address the laws and regulations governing the recognition of agents, attorneys, and other persons representing claimants before the Treasury Department and offices thereof. And so they're representing you before the Treasury Department, which the IRS is an office of. Now, this didn't say the Department of Treasury, this said the Treasury Department, which that's interesting, because there is two different ones. This is the gal that people say is in Puerto Rico. Okay, but Treasury Department circular. Okay. So it's the Treasury Department. Okay. Not necessarily the Department of the Treasury, although they could be connected. It's the Treasury Department that has jurisdiction in this particular field. And the Circular 230 is, it's a book of laws and regulations that governs what these people have to do. It's pretty powerful stuff. We'll be taking a look at it. Becoming an enrolled agent. To become an enrolled agent, an applicant must obtain a PTIN and achieve a passing score on all three parts of the Special Enrollment Examination, which covers many aspects of the Internal Revenue Code, or must have worked for the IRS for 5 consecutive years in a position which regularly engaged in applying and interpreting the provisions of the Internal Revenue Code and the regulations relating to income, estate, gift, employment, or excise taxes. A background check, including a review of an applicant's personal and business tax compliance, is conducted after the applicant files a Form 23. So what do they got to file? It's called a Form 23. Application for enrollment to practice before the Internal Revenue Service, within 1 year of completing all three parts of the examination. Okay, how do you maintain it? Well, they got to do so many hours of CPE every year. 16, it looks like they're saying. Renewal. Individuals admitted to practice at any time during the enrollment cycle. 3 successive enrollment periods preceding the effective date of renewal must complete 2 hours of continuing professional education for each month of enrollment. Failure to renew. Practice before the IRS. Enrolled agents and other practitioners. The right to practice before the Internal Revenue Service is regulated by federal statute. Hey, I think I read that before. This may be a repeat. The FATP status is granted to attorneys, certified public accountants, enrolled agents, each having unlimited representation rights before the Internal Revenue Service. These practitioners may represent their clients on any matter, including audits, collection actions, payment issues, tax refund matters, and appeals. FATP status is also granted with limited representation rights to enrolled actuaries, enrolled retirement plan agents, and registered tax plan preparers. So they have all these different people, but the highest one is the enrolled agent. So, why mess around? Enrolled agents, like other FATPs, are subject to a set of procedures and regulations described in Treasury Department Circular number 230. Regulations governing the practice of attorneys, certified public accountants, enrolled agents, enrolled actuaries, appraisers before the Internal Revenue Service. When practicing before the Internal Revenue Service, enrolled agents may not use the term certified in describing their professional designation. An enrolled agent admitted to practice before the Internal Revenue Service may not state or imply that an employee-employee relationship exists between the enrolled agent and the Internal Revenue Service. Practice in the federal courts. Enrolled agent status does not authorize the enrollee to practice before the United States Tax Court or in any other court. Practice in the U.S. Tax Court is limited to members of the bar of the court. However, the Internal Revenue Code states no qualified person shall be denied admission to practice before the tax court because of his failure to be a member of any professional calling. Non-attorneys must pass a tax court exam for admission to the bar of the court. You don't have to be an attorney at law to practice before the tax court. You just have to take a test. If you pass the test, well, you can practice before the court. Attorneys are admitted to the bar of the tax court without having to take the tax court examination. Okay, that's good enough for them. They can, they're going to base it on their other credentials. But it doesn't mean that you couldn't. In fact, you can download the test questions, or you can pay to have 50 cents a sheet for the test questions. And so I haven't done that yet, but I may just do this. Legal representation at issue. After the Civil War, many Americans brought war loss claims against the U.S. government, often for dead or missing horses. A post-war industry emerged of agents who would press war loss claims for a fee, usually a percentage of the claim collected. Soon, claim values were being fraudulently inflated. In response, the government started regulating these intermediaries, barring unscrupulous ones and certifying honest ones as enrolled agents. A title that is still used today by people who represent clients in matters before the IRS. The IRS is arguing the tax return preparers represent their customers in much the same way as enrolled agents, so the agency should be able to expand regulations to include preparers. So this is a difference between a tax preparer, this part here, and an enrolled agent. But the Institute of Justice is arguing that tax return preparers do not carry out the same level of representation, but rather merely provide a paid service for clients. Preparing a tax return is not a representative act, Alvin said. It is performing a service, certainly, but there's no representation. So a tax preparer isn't the same as an enrolled agent. About the NAEA is an organization powering enrolled agents, blah, blah. What is an enrolled agent? They're the only federally licensed tax practitioners who both specialize in taxation and have unlimited rights to represent taxpayers before the Internal Revenue Service. Well, how would they do that? You'd have to give them a power of attorney. And they have a powerful power of attorney on the IRS website. Like one page is for you, and the other page is for this enrolled agent. So, well, there you are. That's what we're talking about, those people there. Now, what else can we do here? Okay. So let's look at the I want to show you. Well, I guess what I want to show you is, all that being said, these people may not have filled their paperwork out properly. And so if we were to look at the documents that they had to fill out to become a enrolled agent, this is in case any enrolled agents watch this video. Just a second, I'm going to show you something. I got a really slow computer though. Forgive me for that. I'll tell you what I'll do. Okay, what I wanted to show you was that write-up said that a couple of forms had to be done by those who want to become enrolled agents in the IRS, or for the IRS, before the IRS. And one of them is, first they had to have a PTIN number, and that's gotten from filling out a form W-12, IRS Paid Preparer Tax Identification Number, Application and Renewal. And without going through the whole thing, the part of interest is this right here. Name and PTIN. First name, middle name, last name. I don't see any middle initials being used. Do you? First name, middle name, last name. And when they do this form, they're going to fill it out, and it will all be under penalties of perjury. Simple enough. Then they have to fill out this Form 23, Application for Enrollment to Practice Before the Internal Revenue Service. All right, so here's Social Security number, and that was here, right? So that's how these two would be tied together, is by the Social Security number. But look it says your full legal name. And here they want you to put your name, last name, first name, M. It doesn't say middle initial. It just says M. With a space about big enough for one letter. Right? So, your full legal name. Well, is your full legal name your last name, first name, M? Let's find out. Full legal name, according to 6 CFR 37.3, that would be Title 6, Homeland Security, Chapter 1, Department of Homeland Security, Office of the Treasurer, or Secretary, Part 37, Real ID, Driver's Licenses and Identification Cards, Subpart A, hyphen, General, full legal name means an individual's first name, middle names, last name, or surname without use of initials or nicknames. First name, middle name, with an S if there's more than one, last name. Hey, that's how they did it on the W-12 to get the PTIN number. But on the Form 23, which they would fill out afterwards, well, they said their full legal name was last name, first name, middle name, or M. So in other words, if they did this one, well, under penalties of perjury, well, you can't have a name both ways, so on one of these they committed perjury. And so this was done on purpose. My point of all this, I'm not blaming the enrolled agents. Somebody did this on purpose, right? This is deception, at least, to get you on a question that you're going to commit to penalty of perjury to say your full legal name and then put it, guide you into putting your last name, first name, middle initial. And so I hadn't done this yet. I was wondering what I should do with this. So I had written a complaint to the office that's over this, but I haven't sent one to TIGTA yet, the Treasury Inspector General for Tax Administration. I believe that's who I'll go to next. But that being aside, they are still who we had to deal with. And here's their rules. It's in the Treasury Department Circular 230. You just need to Google Treasury Department Circular 230, and you can have your own copy of this. And it shows that there is a statute, 31 U.S.C. 330, practiced before the department, that is the basis for this, subject to Section 500 of Title 5. The Secretary of the Treasury may regulate the practice of representative persons before the Department of Treasury, blah, 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 blah. Where did it say? Actually, I got a better one of these because I did it this way here. Any enrolled agent properly licensed to practice as required under rules promulgated under Section A, so as long as they followed Section A, shall be allowed to use the credentials or designation enrolled agent EA or E.A. So if they have that behind their name, right, then they have been authorized by the Department of Treasury to represent you before the Department of Treasury. So, yeah, it's pretty powerful. Table of contents. Let's see what some of this stuff says. So this first one is scope of the part. Subpart A, rules governing authority to practice. Okay, and subpart B is describes their duties. Subpart C describes the sanctions. D contains the rules applicable to disciplinary procedures. And subpart E of this part contains general provisions regulating the availability of official records. So a lot of information in this circular. It's only 44 pages, so it's not really long. But basically, the Commissioner shall establish the Office of Professional Responsibility and any other offices within the Internal Revenue Service necessary to administer and enforce this part. The Commissioner shall appoint the Director of the Office of Professional Responsibility and any other Internal Revenue official to manage and direct any office established to administer or enforce this part. Offices established under this part include but are not limited to. And so as I'm reading this and thinking about the things other things I've read since I first came across this and so forth, that they're guiding you to contact the Office of Professional Responsibility because it's the one that they name. But they go ahead and they say that there's also any other Internal Revenue official to manage and direct any officers offices established to administer and enforce this part. So somebody else could have the duty to enforce this. If you write the director, you've wrote the wrong office. They're kind of sneaky that way. The Office of Professional Responsibility, which shall generally have responsibility for matters related to practitioner conduct, and shall have exclusive responsibility for discipline, including discipline proceedings and sanctions. An office with responsibility for matters related to authority to practice before the Internal Revenue Service, including acting on applications for enrollment to practice before the Internal Revenue Service and administering competency testing and continuing education. So this Office 2 is different than the Office 1. And this is the office that has that's over the form, or the form has an error in it. That they're making people say that their full legal name is their last name, first name, initial. Okay, designate an office, employee, Internal Revenue Service to perform the duties of an individuals appointed under paragraph A of this section, blah, 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 blah. Definitions. Attorney means a person who is a member in good standing of a bar of the highest court of any state. Practice before the Internal Revenue Service comprehends all matters connected with presentation to the Internal Revenue Service or any of its officers or employees relating to taxpayers' rights, privileges, or liabilities under laws or regulations administered by the Internal Revenue Service. One thing I didn't pull up that I should. Go get it right now. The Taxpayer Bill of Rights, which is in the what do they call it? The National Taxpayer Advocate, I think it is. So, I don't know if you can read these. I could have found a better one, but the right to be informed, the right to quality service, the right to pay no more than the correct amount of tax. Well, that's the main one right there. Did you pay too much tax? The right to challenge the IRS's position and be heard. The right to appeal an IRS decision in an independent forum. The right to finality, the right to privacy, the right to confidentiality, the right to retain representation. And that's who the EAs are, their representation. The right to a fair and just tax system. Now, the problem with the EAs is they filled their paperwork out, so they committed perjury. So there is nobody to represent you. Could always be your claim to them is I can't get representation. They've all committed perjury. So you violated my Bill of Rights. I don't know if we're going to have to use that or not, but it's just good to know. Right? Practice before the Internal Revenue Service comprehends all matters connected with. I have it bigger. Presentation to the Internal Revenue Service or any of its officers or employees relating to a taxpayer's rights, privileges, or liabilities under laws or regulations administered by the Internal Revenue Service. Such presentations include, but are not limited to, preparing documents, filing documents, corresponding and communicating with the Internal Revenue Service, rendering written advice with respect to any entity, transaction, plan, or agreement, or any other plan or arrangement having a potential for tax avoidance or evasion, representing a client at conferences, hearings, and meetings. Alrighty. And these are the people that can. An enrolled agent, as an agent pursuant to this part, who is not currently under suspension or disbarment from practice before the Internal Revenue Service, may practice before the Internal Revenue Service. Well, look at that. They can practice before the Internal Revenue Service. Filing with the Internal Revenue Service, written declaration that an attorney is currently qualified as an attorney. Okay, that's how an attorney can get in. Application to become an enrolled agent, forms. Well, we already talked about that. They got a little problem with those. Representing oneself. I want to get down to duties and restrictions relating to practice before the Internal Revenue Service. A practitioner must, on a proper and lawful request by a duly authorized officer or employee of the Internal Revenue Service, promptly submit records or information in any matter before the Internal Revenue Service, unless the practitioner believes in good faith and on reasonable grounds that the record or information are privileged. So make sure you tell the guy this is privileged information. Then he can't share it with the IRS. Knowing knowledge of client's omission. A practitioner who, having been retained by a client with respect to matter administered by the Internal Revenue Service, knows that the client has not complied with the Internal Revenue laws of the United States or has made an error in or omission from any return, document, affidavit, or other paper which the client submitted or executed under the Internal Revenue laws of the United States, must advise the client promptly of the fact of such noncompliance, error, or omission. Excellent. Right? That's what I want to tell them. I didn't pay any taxes in my proper person name. There's an error in the records. We need to go fix it. Diligence as to accuracy. In general, practitioner must exercise due diligence, which has its own definition, what due diligence is, and it says they must exercise it. So whatever that means, they got to do. In preparing or assisting with preparation, approving, filing tax returns, documents, affidavits, other papers related to the Internal Revenue Service. In determining the correctness of oral or written representation made by a practitioner to the Department of Treasury. Yada, yada, yada. A practitioner may not take acknowledgments, administer oaths, certify papers, or perform any official act as a notary public with respect to any matter administered by the Internal Revenue Service, and for which he or she is employed as counsel, attorney, agent, or so forth. So you would have to go to a notary public. That's interesting. See here that says notary public. Normally when they say you need a notary, it doesn't say notary public, it says you need a notary. And so there's civil law notaries and there's common law notaries. A notary public would be like a common law notary. Civil is just called a notary. Most attorneys are notaries. They're just not notary publics. And so a notary public can't create a legal document, but a notary can. Right? They can certify that you signed a legal document. So that's the point. The forms that they would have us do are already created by the IRS. You go to the notary public just to have them certify that you filled out the document, and then you would give it to these people, which is different than creating the legal document, which is what a notary does. Civil law notary, that is. Fees. A practitioner may charge a contingent fee. Well, that's outstanding. That's what I want them to do. Because, what I'm going to ask them to go find for me is found money. I didn't know it existed before, but if it's mine and it was kept from me by fraud, then paying somebody a portion of the proceeds is fine with me. Especially if they charge 3 times damages. Here, you get one of the damages, the state gets another damage, I get my original and a damage. 2 for me and 1 for each of you. They may charge a contingent fee for services rendered in connection with any judicial proceeding arising under the Internal Revenue Code. Well, if it arises under the Internal Revenue Code, then it's going to be heard in the IRS or in the tax court. Now, you could go to the district court, which is where they try to send people with IRS issues, is to the district court. But if you read what it says about the district court, it says you have to have paid the tax first before you can go and defend yourself. But you don't have to do that in the tax court. You don't have to pay it first. U.S. tax court. Contingent fee is any fee that is based in whole or part on whether or not a position taken on a tax return or other filing avoids challenge by the Internal Revenue Service or is sustained either by Internal Revenue Service or in litigation. So if they win, they get paid. Paid for performance. In general, a return of client's records. In general, a practitioner must, at the request of a client, promptly return any and all records of the client that are necessary for the client to comply with his or her federal tax obligations. So that's what you tell them. You need any and all records that are necessary for you to comply with your federal tax obligation, which is more than just income tax. We'll get into that in just a second. Negotiation of taxpayers' checks. They can't do it. Practice of law. They can't do it. Not practicing law, they're practicing equity. Establishing the facts, determining which facts are relevant, evaluating the reasonableness of any assumption or presumptions or representations, regulating the applicable law, including potentially applicable judiciary doctrines and relevant facts, arriving at conclusions supported by the law and the facts. Advising the client regarding the import of the conclusion reached, including, for example, whether a taxpayer may avoid accuracy-related penalties under the Internal Revenue Code if a taxpayer acts in reliance on the advice. Now remember, these enrolled agents are the highest credentialed. It's the highest credential offered by the IRS. And they're called enrolled agents. Does that put them above a special agent of the IRS? I don't know. They just said it's the highest credential you can get. It's called an enrolled agent. So if they say it to the IRS has pretty much got to believe it. Oh, where where are we now? Standards with respect to tax returns, blah, blah, blah. It's willful attempt by a practitioner to understate the liability for taxes or reckless or intentional disregard for rules or regulations by a practitioner, as described in some sections of the code. Competence. A practitioner must possess the necessary competence to engage in practice before the Internal Revenue Service. Well, that must make the Internal Revenue Service a court of competent jurisdiction, because you have to be competent to practice there. Requirements for written advice. A practitioner may give written advice, including by means of electronic communications, concerning one or more federal tax matters subject to the requirements of paragraph A2 of this section. The practitioner must base the written advice on reasonable factual and legal assumptions, including assumptions to future events. Subpart C, sanctions for violations of these regulations. Authority to censure, suspend, or disbar. Shown to be incompetent or disreputable within the meaning of subsection 1051, which is down here. And so here's some of the things that they can get in trouble for. Being convicted of a felony, giving false or misleading information, or participating in any way in the giving of false or misleading information to the Department of Treasury or any officer or employee thereof, or to any tribunal authorized to pass upon federal tax matters in connection with any matter pending or likely to be pending before them, knowing the information to be false or misleading, facts or other matters contained in the testimony, federal tax returns, financial statements, applications for enrollment, right? Facts or other matters contained in applications for enrollment, such as having your name backwards when it asks for the full legal name. That's what I'm saying. See, it's like they're entrapped. But continuing on, willfully failing to follow a federal tax return, didn't say income tax return, federal tax return, in violation of the federal tax laws, or willfully evading, attempting to evade, participate in any way, evading, attempting to evade any assessment or payment of any federal tax. Giving a false opinion, knowingly, recklessly, or through gross incompetence, including an opinion which is intentionally or recklessly misleading, such as telling you, well, you need to go talk to an attorney at law, instead of them taking your case to say, no, you need to go get an attorney at law. No, I don't need an attorney at law. I'm not going to a court of law. Everything you're trying to do is before the IRS. And the reason is, well, that's whose forms this stuff has been put on, as the IRS's forms. Why would I go to someplace other than the IRS? False opinions described in paragraph A13 include those which reflect the result from knowing misstatement of fact or law, from assertion of a position known to be unwarranted under existing law, from counseling or assisting in conduct known to be illegal or fraudulent, from concealing matters required by law to be revealed. And so our thought in this is that so like on a mortgage, right? It's a investment contract upon which you are the unknown investor. I don't think it's unknown, but I guess that would work for this. Undisclosed investor. However, they've had to put in some IRS forms as part of doing a REMIC or any other securitization, I'm believing. And so then there's these IRS forms that are at least have some identifying information of you on them, such as maybe your Social Security number. So they could do a sort on your Social Security number and get all the different 1099s that come up. If there's a bunch of 1099s that come up that have your Social Security number on them, and you don't know about them, and you see some 1099As where somebody else is claiming your property, you would say, hey, no, that's my property. I want my property. Somebody has, that's a mistake, apparently. So I don't need to go to court. I need to fix the forms. right? And so this is an administrative remedy to get the forms corrected to release your property to yourself. And if the taxes haven't been paid, then maybe these things can't be released. And this is the point. The tax hasn't been paid. So who's ever doing it this way, without your knowledge, is doing it to avoid taxes. Well, that would be from concealing matters required by law to be revealed. Hey, they're tax evaders. That's the job of the IRS, to collect taxes. So receipt of information concerning a practitioner. So, right, this is the thing. Now, all this being said, well, what if they won't do it? Well, then you're supposed to contact somebody. Any person other than an officer or employee of the Internal Revenue Service having information of a violation of any provision of this part may make an oral or written report of the alleged violation to the offices of the Internal Revenue Service responsible for administering or enforcing this part, or any officer or employee of the Internal Revenue Service. So I should be able to give it to anybody, and it should get to whoever it needs to go to. And if it doesn't, that's when you go to the Treasury Inspector General for Tax Administration to say, hey, they're not doing what they're supposed to based on these laws. Because that's what the Inspector General does. He oversees tax administration. And they do contact you. I've got a complaint in with them right now, and actually have a complaint number from TIGTA. And then it goes on and on. Then they can get different kinds of charges. A complaint must name the respondent, provided a clear and concise description of the facts, laws, constitute basis, proceeding, blah, 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 blah. So this complaint doesn't come from you. It comes from the Internal Revenue Service to this person, and it's done kind of like it looks to me like it's a subpoena, show cause hearing. Okay, I'm not going to spend too much more time on this. We've got other things to look at. But by and large, here's the laws that govern practice before the Internal Revenue Service. Okay, now, to show you that they don't mess around, this is enrolled agent information, as you see, IRS website. And you can go to the enrolled agent's home, or you can go to this thing called the IRB. Well, if you click on IRB, it takes you to Disciplinary Sanctions Internal Revenue Bulletin. The Office of Professional Responsibility publishes all disciplinary actions in the Internal Revenue Bulletin. Published sanctions include censure, suspension, disbarment before the Internal Revenue Service. This listing provides the bulletin number, date, page of the sanctions imposed by the OPR since 1988. A practitioner's eligibility to practice before the IRS may have been reinstated since the publication of discipline in the IRB. To verify a practitioner's current status to practice, please contact Internal Revenue Service, Office of Professional Responsibility, attention, SE, OPR, blah, 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 blah. But let's just look at one. So here's a bulletin. Okay. Internal Revenue Bulletin, highlights in this issue. Refer to identify subject matter covered, blah, blah, blah. So there's different things covered in here. And what we want to look for is items of general interest. Announcement of disciplinary sanctions from the Office of Professional Responsibility. The Office of Professional Responsibility announces recent disciplinary sanctions involving attorneys, certified public accountants, enrolled agents, enrolled actuaries, enrolled retirement plans, enrolled, licensed and enrolled. Right? If you do wrong, you may end up on this list. And then they have these. Oh, what happened there? Hello? Sorry about that. I don't know what I did there. So then they have the different kinds of sanctions that can be done. Disbarment by decision on appeal, disbarment by consent, suspended by consent, censored by consent, all sorts of things. Well, let's look real quick and see what they do. Did they list anybody? Well, they did. So in Lafayette, California, Scott M. Crawford, see, he got his name backwards, Crawford Scott M. Hey, that's how they have you fill out that paperwork. Suspended by default decision in expedited proceeding under 31 CFR 1082. Indefinite. Suspended by default decision. Suspended by decision in expedited proceeding. Suspended by decision in expedited proceeding. Suspended by default decision in expedited proceeding. Suspended by default decision in expedited proceeding. All of this is done by 31 CFR 1082. Hey, we were looking at that. Where is that? I think that would be in here. Find 10.82. Come on. Okay, what is an expedited suspension? When applicable, whenever the commissioner or delegate determines that a practitioner is described in paragraph B of this section, the expedited procedures described in this section may be used to suspend the practitioner from practice before the Internal Revenue Service. To whom applicable, this section applies to any practitioner who, within 5 years prior to the date that a show cause order under this section, expedited suspension procedure is served. So how do they do it? They send a show cause order. Has had a license to practice as an attorney, certified public accountant, actuary, so forth and so on. Has, irrespective of whether appeal been taken, been convicted of a crime. Has violated conditions imposed by practitioner, so forth and so on. So the expedited suspension is done by a show cause hearing. I'll go up here. Let's see if it says expedited. Default. Okay. Suspended indefinitely by decision and expedited proceedings. Suspended indefinitely by default decision and expedited proceedings. Suspended by consent or expedited proceeding. OPR instituted an expedited proceeding for suspension based on certain limited grounds, including loss of professional license, for cause, and for criminal convictions. So those are the reasons that they can do it, right? Based on certain limited grounds, including loss of professional license, for cause, and criminal convictions. So all these people, for criminal convictions or for cause, have been suspended by default indefinitely. And once they've been suspended, they can also be, they can also be penalized, a monetary penalty. So that's just kind of interesting. All right, one more time to the well. Be right back. Okay, there's so many different little things to cover that I got to kind of skip around a lot. When we're all done, we'll be looking at things to do with a REMIC, which is real estate, mortgage, investment, contract, or something like that, which has to do with your mortgage-backed security that they took and, they securitized. But before we get there, because we're going to be talking to these people that are called registered agents, enrolled agents, to make sure we're doing it right with them. So this is the power of attorney and declaration of representative form that they would have you sign. And while I don't know anything about anything, if it asks for my name, I'm not going to use a middle initial. I'm Robert Allen Ritlewski. I'm the taxpayer that needs to get things corrected in his records because apparently it has some dude in there with a middle initial name. And that is evidenced by here, and I've shown this numerous times, that this little piece of paper here is the stub that comes off of a Social Security card. Social Security account number. Well, that would be mine. All right? And then it says Robert A. Ritlewski with this address, which was my old address as a child. Didn't have my zip code on it, though. For Social Security and tax purposes. And sure enough, my whole life, my tax forms came to me in a middle initial name. They didn't come to me in my name, Robert Allen Ritlewski. And this here is the back side of that stub, and it says, detach this portion from the upper half of the card and keep it in a safe place. Your name and Social Security account number appear on the other side. Well, this is the name here, and that's not my name. But this is the name that's in your file, right? And so this is a legal fiction, or it's a pseudonym, an AKA, but it's not you, and I don't need to pay its taxes. But they keep sending me forms saying it's, his taxes, or that it's mine. Well, if that's the case, the government says my name's Ritlewski Robert Allen, which is different than Robert A. Ritlewski. So I don't know who this character is, but what he's done is he's clouded the title to the Social Security account, which should be for Robert Allen Ritlewski. That's why, getting this stuff right is what it is. And so we have an all caps name, right? And that, to me, is the entity that would go on entity classification election form. Name of eligible entity. That would be your all caps. Probably comma LLC, but here's why. Entity classification election. This is from Wikipedia. For United States income tax purposes, a business entity may elect to be treated either as a corporation or as other than a corporation. This entity classification election is made by filing Internal Revenue Service 8832. Absent filing the form, a default classification applies. So if you didn't fill this out, it applies. A U.S. corporation of the type that can be publicly traded must be treated as corporations. There is a list of specific foreign entities that must be treated as corporations. The election is effective for federal and most state income tax purposes. If an entity is not classified as a corporation, it is treated as a partnership for U.S. tax purposes if it has more than one owner, or as a disregarded entity if it has a single owner. It is treated as part of the single owner. The classification of either a U.S. or non-U.S. entity for U.S. tax purposes has no effect for purposes other than U.S. income taxes. Okay, so we have this entity, your all caps, that has one owner, you, and if you haven't selected what type of entity it's going to be considered, it will be considered disregarded entity if it has a single owner. An entity which is eligible to make an election is referred to as an eligible entity. Generally a corporation organized under U.S. federal state laws. Blah, 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 blah. An eligible entity is classified for federal tax purposes. Now, I didn't say just income tax. Now, this is federal tax purposes. Under the default rules described below, unless it files an 8832 or a 2553 election for a small business corporation, that probably your child, to elect a classification or change its current classification. right? So unless you've done it, you're going to be considered disregarded entity. Unless an election is made on Form 8832, a domestic eligible entity will be classified by default as a partnership if it has two or more, disregarded as an entity separate for its owner if it has a single owner. A change in the number of members of an eligible entity classified as an association, filed below, does not affect the entity's classification. So, single member limited liability companies. This is from the IRS website. Single member limited liability companies. An LLC is an entity created by state statute. Depending on elections made by the LLC and the number of members, the IRS will treat the LLC as either a corporation, a partnership, or as part of the owner's tax return, disregarded entity. Right? So your all caps is an LLC, limited liability company. One owner. That's like a corporate sole. Well, not yet, but it could be. Specifically, a domestic LLC with at least two members is classified a partnership on federal tax purposes unless it files 8832, yada, yada, yada. Got to file the 8832. If a single member LLC does not elect to be treated as a corporation, the LLC is a disregarded entity, and the LLC's activity should be reflected on the owner's federal tax return. Again, it didn't say income tax, it said the federal tax return. If the owner is an individual, the activities of the LLC will generally be reflected on a 1040, 1040, different 1040s. An individual, but not specifically, just generally, right? There could be other forms. An individual owner of a single LLC that operates a trade or business is subject to tax on net earnings from self-employment in the same manner as a sole proprietorship. If the single member LLC is owned by a corporation or partnership, the LLC should be reflected in the owner's federal tax return as a division of the corporation or partnership. Taxpayer identification number. For federal income tax purposes, a single member LLC classified as a disregarded entity generally must use the owner's Social Security number or EIN for all information returns and reporting related to income tax. For example, if a disregarded entity LLC that is owned by an individual is required to provide a W-9, request for taxpayer identification number, and certification of W-9 should provide the owner's SSN or EIN, not the LLC's EIN. So the LLC should have its own number. However, for certain employment tax and excise tax requirements discussed below, the EIN of the LLC must be used instead. And this is the thing. You got to have a separate number for your LLC other than your Social Security number. Therefore, an LLC will need an EIN if it has any employees or if it is required to file any of the excise forms listed below. Thus, most new single-member LLC classified as disregarded entities will need to obtain an EIN. An LLC applies for an EIN by filing an SS4 application for employee identification number. A single-member LLC that is disregarded entity that does not have employees and does not have excise liability does not need an EIN. It should use the name and TIN of the single member owner for federal tax purposes. Use the name and TIN of the single member owner. Again, it's not your Social Security. You would need to get a TIN. Because we've not filled out an 8832, we are considered a disregarded entity, or our all caps is considered a disregarded entity. If that's the case, a single member LLC that is a disregarded entity that does not have employees and does not have excise tax liability, well, we don't really have any excise tax liability because we pay the tax at the pump or on the pack of cigarettes, the bottle of booze, whatever it is, the stamps, right? Those are the tax. They've been paid, so we don't have a tax liability. So we don't need an EIN. So it should use the name and TIN of the single member owner for federal tax purposes. However, if a single member LLC whose taxable income and loss will be reported by a single member owner nevertheless needs an EIN to open a bank account, or if state law requires that the single member LLC to have a federal EIN, then the LLC can apply for and obtain an EIN. So if you want to get a bank account in your all capital letter name, then you need to apply for an EIN for it. I guess is what it's saying. And so this is why we're going to go ask an expert. Employee tax and certain excise taxes. Okay, so this employment tax is the interesting one, because we may have paid the excise taxes at the pump, but employment taxes are like the FICA taxes, if I'm not mistaken. And those are considered separate from the disregarded entity, and so you're supposed to use, right, a different name and TIN number. So you wouldn't use the same number you would for income tax, because they're not different for income tax, but they're different for excise tax and employment taxes. A single member LLC that is classified as disregarded entity for income tax purposes is treated as a separate entity for purposes of employment tax and certain excise taxes. The wages paid after July or January 2009, the single member LLC is required to use its name and employee identification number for reporting and payment of employment taxes. A single member LLC is also required to use its name in the EIN to register for excise tax activities on Form 67, blah, 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 blah. So again, it's like there's another number for your EIN. Even if it's disregarded for income tax, which means it's considered the same as the owner, they're separated when it comes to excise taxes and employment taxes. And for those, you got to use a different number and the name of the owner, I believe, is what this was saying up here, in the name and the TIN of the single member owner for federal tax purposes. Well, not for the income tax. That was already taken care of. This would be for the employment tax. And so without getting too confusing, right, this is just single member limited liability company. This is off the IRS. So this is what we'll talk to the enrolled agents about to get a better understanding about, well, what does this mean with this disregarded entity? Because here's the form. And the interesting thing about this form, so here's the form. It's a very simple form. I'm not going to spend a lot of time on the front, but if the eligible entity has only one owner, provided the following information: name of the owner. Well, you'd put your name in there and your Social Security number. For you, right? Identification number of the owner, not the identification number of the business. The business will have its own identification number. And then you could pick these different choices. And in Part 6, A, B, C, D, E, F. 3 are for foreign and 3 are for domestic. So let's just get rid of half of them. We'll just look at the domestic. These are your choices. A domestic eligible entity electing to be classified as an association, taxable as a corporation. A domestic eligible entity electing to be classified as a partnership. A domestic eligible entity with a single owner electing to be disregarded as a separate entity. Well, it already is that by default if you didn't do this. A partnership is just, two single entities that get together and make a partnership. That's not a corporation. That's a common law partnership. So the only thing you could change it to is from being a disregarded as separate entity is to a domestic eligible entity electing to be classified as an association, taxable as a corporation. And if you go look up the definition of association, it'll talk about that's what states are. Unions of states are associations. So is that what puts you into the government or into the country by, checking that box instead? You're already C. If you haven't filled this form out, you're already considered C as a single individual. If you're married, you're going to be considered B. Doesn't mean you don't have a C, but you're going to have a B for sure. You have a partnership. But it may be once you get married, right? That gets rid of the disregarded as a single, more than one owner, and now there's two owners because it is a partnership. So, right? But what that has to do with Robert A. Rutluski, I don't know, right? Why is he in my tax stuff? So he has to go. All right, give me one more go around. We should be done with this. Okay, all that to say, that all has to do with somebody we're going to go talk to called an enrolled agent. And there could be lots of different reasons to go to them, such as there's errors in your individual master file because it shows, due to the middle initial instead of your proper name. Well, there's enough reason right there to go. But let's say that you have a mortgage and it was somehow involved in a REMIC. So that's what, all the things to do with, like mirrors, are part of this. So let's just use that as our example. And so you don't need to be in foreclosure for this. You just go down and say, when you understand that that's your property, well, then how do I collect my property? Right? If somebody put in a 1099-A that you abandoned your property to the IRS, it would just seem like, well, I need to go tell the IRS, apparently, that I didn't abandon the property. And that's what enrolled agents do. They represent you before the IRS for anything to do. Unlimited representation before the IRS. Highest credentialed individuals, highest credentials of the IRS are enrolled agents. So give them a power of attorney so they can represent you, which means now you, theoretically, are the highest credentialed individual in the IRS. And you want your property back. Real estate mortgage investment conduit is an entity that holds a fixed pool of mortgages and issues multiple classes of interest in itself to investors under the U.S. federal income tax law. Oh, income tax. Oh, hey, this could have something to do with taxes. Well, we're talking about the king's revenue. That's what tax is, and that's the job of the IRS, is who's ever not paying the tax to go collect the tax. Well, let's tell them that we can't pay our tax because somebody's concealing our property. They're used for pooling of mortgage loans and insurance of mortgage-backed securities, blah, blah, blah. To qualify as a REMIC, an organization makes an election to do so by filing a Form 1066 to the Internal Revenue Service. With who? With the Internal Revenue Service. Why are we going to the Internal Revenue Service? Well, because that's where the forms are filed. I don't need to go to a court of law. I don't need an attorney at law. I need somebody that can represent me before the Internal Revenue Service to find my damn property, because it's been filed on a Form 1066. To qualify as a REMIC, an organization makes an election to do so by filing a Form 1066 with the Internal Revenue Service and by meeting certain other requirements. Well, here's a Form 1066. U.S. Real Estate Mortgage Investment Conduit, REMIC, income tax return. Name. Well, that would be the name of the REMIC. I'm believing. This is interesting, right? What does that mean, name? Because it's got an employee identification number. Does a REMIC have an employee an EIN number? That's interesting. Now, so how do you find yours? Well, look at this. They got a publication 938, Real Estate Mortgage Investment Conduits, Reporting Information and Other Collateralized Debt Obligations. And what this thing is, it looks like, is Directory of REMICs and Other CDOs for the first quarter of 2016. So let's just look at one here. Bank of America. I'll use Bank of America. Merrill Lynch Large Loan, Inc. Com Mortgage PT Cert something or other. Upper Tier REMIC. Gives the QSIP number, the classes, I don't see an EIN number on here. Right, but so what it looks like is all the different REMICs that are put together, like this is just for the first quarter, 2016. So if you were to go to the year of your loan, you should be able to find from the IRS this document that's going to say, which one yours is part of and what the CUSIP number is. And other interesting information. So, a REMIC itself is exempt from federal taxes, though income earned by investors is fully taxable. Well, again, you're supposed to be the undisclosed investor, and if you haven't paid the income tax yet, well, then you're a tax evader, right? So we need to, there's an omission in the record. We need to fix it. But if we do pay the taxes, I believe this is the thing. Once you pay the taxes, the property can be released to you. I'm using that as my reasoning to go through all this, right? Because that's how we can get a release, is going and paying the taxes. I'm not going to figure it out. I'm going to let an expert do it. To qualify as a REMIC, an entity or pool of assets must make a REMIC election, follow certain rules as to its composition of assets, adopt reasonable methods to prevent disqualified organizations from holding its residual interest. The Internal Revenue Code does not appear to require REMICs to have a class of regular interest. Okay, whatever all that means. I don't know if that means anything at this point other than I think what they do when they put these together and they securitize them, right? So here's an example. HSI Asset Securitization Corporation Trust 2006 Opt 2. Interest in these mortgage trusts were then sold to teachers' units, and okay, that's what they did with them after they securitized them. What they do is, where did it say that? SEC regulations, which exempt the entity of filing an annual report whereby the number of claimed investors has fallen below the SEC registration and reporting threshold of 300 persons. Because listening to the gentleman named John, the paralegal, or reading what he had said in the videos I did before, that at some point these are registered with the SEC, and then at some point they put in a thing called a 15D, all right, the Form 15. And now they're going to say they no longer have to annually report. And the reason for that could be because they're below the 300-person threshold. So I'm thinking that in these REMICs, when they bundle them in groups of less than 300, so that once they've been first registered, they don't have to be reported. They just kind of, disappear. It doesn't mean that they're not registered with the SEC. They're just not reported yearly because they have less than 300 people. But they still exist. And this document here from the IRS would be the evidence that they do exist. But when you look at the forms anyways on these things, like so here's the 1099 OID. It's got a CUSIP number on. Which one has the CUSIP number on it? That must be the B. Where's the B? B. No, not that one. This one. Yeah, CUSIP number. Recipient's identification number. Are they using your Social Security number? Or again, is John, the paralegal, told Bob, who called him, different Bob, that when he was doing this research, he found that they take your Social Security number and they use the same numbers and move the dashes, basically, make it different form and number, but it has the same numbers on it. So that could be your identification number. Your TIN number that you're supposed to have could be your Social Security number with a dash someplace else. This is why it's so important to get all that straightened out. We need to look at the individual master file and get all these little things straightened out for us. Recipient's name, proceeds. This is the value 1D. This is what the thing is worth. Federal income tax withheld. Well, this would show this is what it's worth, and the income tax has been withheld. So this is still what it's worth in the proceeds. Right? That's your property. This is like your claim check to say, hey, that's my property, and this is what it's worth. Right? Again, it's an IRS form. Why would I go to anybody but an expert in the IRS if this is the form? And if somebody put in a 1099-A to say they're claiming this because I didn't, or the 1099 OID because I didn't, well, then what form do I put in to say, well, no, I do claim it? Right? What do I need to do to claim it? That's what we want to do. All right, go to enrolled agent. Let them tell us. Okay. All right. So that's pretty much it, right? That's the whole reason for doing this. They had to put in a 1066 if they did a REMIC, and if that's what your mortgage has been pooled, then somebody had to put in a Form 1066. And while I haven't gone through this thing to read it all to see what's all in there, I just know that, well, they had to put in a Form 1066. So there must be a way to track this back to your REMIC. And, so I'll look at it closer later. But there was one last thing I wanted to look at. What was that? It was on the front page of my thing here. Where are you? And then we'll be done. And that's in the IRS Processing Codes and Information. Right? This is called the 6209 Manual, or the IRS Processing Codes and Information Manual. And in the beginning of this thing, it has it's got a number of definitions. There's something that was interesting, right? Julian date, the numeric date of the year that the return or document was numbered for processing. For example, January 15th plus MC 15. The 6th, 7th, and 8th digits of the DLN represent the Julian date. They use the Julian date to do your taxes, not the Gregorian date. They're using a different calendar. Where are you, Gene? I wanted to find the taxpayer identification number. Okay. Just a few definitions here, real quick. First of all, the taxpayer information file. A file containing entity and tax data processed at given service center for all TINs. It didn't say Social Security number, it said TINs. A file containing entity and tax data. Well, the entity is your all capital letter name, so it has information about it and information about the taxes. So you're going to want to ask for the taxpayer information file. And the taxpayer identification number, every taxpayer on the master file has a permanent number for identification of the tax account. Okay, we got an account called the tax account. It's got a TIN number. The employee identification number is used to identify a taxpayer's business account. Well, a business account isn't a tax account, or it would have said the tax account. It didn't. It said a business account. So the EIN and the TIN are not the same number. The Social Security number is used as an account number of an individual taxpayer. So the Social Security isn't the tax account, it's the number for the taxpayer. So the 10 is a different number completely from the EIN or the SSN, in my opinion. I want my 10 number. And I believe that there's already one exists, and it's in this taxpayer information file. So if you go to an enrolled agent, you're going to want to ask them to get your taxpayer information file. Anyway, that's what we're working on now is these enrolled agents that they're your attorney before the IRS. And just really quick, what are they? Is the only professional granted a right to practice directly from the U.S. government. Attorneys and certified accountants have state licenses, which limits their practice only to states where they are licensed. Unlike a CPA or attorney, an enrolled agent holds a federal license and has rights to represent any taxpayer in a state regarding federal tax matters. And to go on, they were created under a act of Congress. They're federal agents called enrolled agents. They work for a fee, right? They don't get paid a salary, they work for a fee. An enrolled agent is considered a tax specialist, which sets them apart from attorneys or CPAs who do not always specialize in taxes. Federally authorized tax practitioner empowered by the U.S. Department of Treasury. Enrolled agent status is the highest credential awarded by the IRS. You may want to copy and paste these things and take them in and show these people that you know who they are. And if you want to find one, you just go and Google enrolled agent and go to the NAEA. And tell them you want to find a tax expert. Four, 9, 3, 4, 1. And here we go. All right, EA. Can't put that EA behind your name unless you're an EA. And once you can, well, that's the highest credential there is that the IRS offers. So let them put your paperwork in for you. And because we're trying to collect, what is basically found money, pay their fee, give them a contingent fee, go get my property. We'll see how they feel about doing this as things go on, but that's what's going on. Okay, I hope you found it useful. That's why we're looking for people called enrolled agents and have them do a power of attorney and go get all anything that there possibly can be about you, they can get for you once they have your power of attorney. In fact, they can do it from their computer. If they've enrolled with the IRS, they can have access to your confidential file from their office. Right? And it's like, boom, it should be that quick. Get the confidential file and tell them you want a copy of it. And I don't know what any of this costs. This is where we're at with this. So next week, Bob in Arizona, probably very early in the week, has an appointment, unless this person backs out, with an EA, and beyond looking for everything, just to say, well, let's just start with one. Here's my my MIN number, mortgage identification number that you got from Irs, right? They had to put information in. They had to do if it's a REMIC, they had to put in that 1066 form. So, there would be a way to track all this stuff down that will somehow be tied to you. by reference, by a number of some kind, and probably your Social Security number. So, okay, y'all have a great day. I hope to have more to tell you very soon. We'll see you.